All right, we are now live. You just let me know when you're ready.
Okay, I'll give us a minute here. Doesn't seem right, but. Thank you.
Can I step a good ice pack in my way through?
Oh, Lord. Okay. I think, I'm gonna blow my video out. Guess we can go ahead, Judge.
You ready?
Yeah.
Okay. All right. Good morning. We're going to get started with People versus Jonathan Gillen, file 214985FY. And Mr. Connolly is here on behalf of Mr. Gillen. This is the date for sentencing. And Mr. Connolly, what do you have to say on behalf of your client? Well, first of all, have you reviewed the report with Mr. Gilland, and is it accurate and complete?
Yes, Your Honor. The report is accurate and complete. And just to give you some background on this case, Your Honor, Mr. Gilland had an additional circuit court felony file, which he was sentenced on yesterday. He received a sentence of 8 months jail with community corrections and 2 years of probation. Basically, what happened was he bonded out on that file, and there was an incident with his girlfriend at the motel they were staying at. Law enforcement was called, and when law enforcement showed up, Mr. Gilland sort of took off and ran. He made it about 3 motel rooms down before he stopped. So he didn't get far, Judge, and then he complied with the orders of the officer who caught up to him. So it was a very brief resist obstruct, but it was in fact failure to comply with a lawful order. So just so you know, Your Honor, there's a video of it. I watched the video. Essentially, Mr. Gillen's significant other was assaulting him and just sort of going nuts in the parking lot of the motel. So there may have been some controlled substances involved on her part there, but that was why law enforcement came. So Mr. Gillen and I obviously had this conversation, Judge. When law enforcement shows up, you don't run away, especially when you're on bond. So he understands that what he did was foolish and illegal. So I'm asking that Your Honor consider in this matter sentencing Mr. Gillen to time served and letting him continue with his probation in circuit court, seeing as how this case did in fact stem from him being out on bond on that case. Additionally, Your Honor, Mr. Gillen has just had undergone knee surgery. So he's in quite a bit of pain at the jail, Your Honor. So I had to have surgery, multiple staples. So he's having a tough week, Your Honor. So that being said, I would ask again that you consider sentencing for time served with minimal fines and costs so that he can get started on his circuit court probation.
All right. And you said he got 8 months. Does he have community corrections for that or?
Yes, Your Honor. He has community corrections for that. So I think he's got a pretty good credit figure right now, 100 and some days in the county jail. So some of that stemmed from a district court matter that he was maxed on because of the new circuit court case. So his probation was terminated on a district court case. He received the 93 days. And then again, like I said, he's now received 8 months from circuit court.
Okay, thank you, Mr. Connolly. Anything you'd like to add, Mr. Gillen?
Yes, Your Honor. As you know, it was a mistake on my part, and I was foolish for doing it. I wasn't clearly thinking. But I stopped when I only made it a couple rooms down, and I realized that was a very poorly decision on my part.
Okay. Well, I don't want to interfere with the circuit court probation. If you are going to get some assistance through our community corrections program, I think that would be a good idea. And continued jail time in this case might cause some problems there, even though given your prior record, it would probably be justified to give you the full 93 days. Practically speaking, I don't think that makes any sense. So I'm just going to sentence the defendant to the 42 days in jail. That's the credit for time served. I give Mr. Gillen credit for taking responsibility for his actions. And anyhow, good luck with the probation in circuit court. I would take that seriously. You're 34 years old, and I'll bet you're getting tired of this in and out of jail stuff. And,
yes, sir.
There's no reason why you can't get all this behind you and get back to working and get on with your life. So I wish you success there.
You're waiving fines and costs.
I am going to waive fines and costs, given the fact that the defendant is incarcerated and unlikely to be able to pay those anyhow in any reasonable amount of time. Let's see. I am going to impose, however, the $75 crime victim fund fee, $50 judicial system fee fund fee, and there's a court-appointed attorney fee of $650. So, but fines and costs are waived. So, all right, we're all set then. And once again, good luck, Mr. Gillen. We're all set. Hope the pain goes away there soon. Yeah.
Hopefully.
Thank you, Your Honor.
Thank you, sir.
Yeah. Thank you, Mr. Connolly. So let's go back to the Wakala case. Let me see if he got out of the breakout room okay. There he is. Mr. Walaka, can you hear me okay?
I believe that's,
Well, we're having all.
Your Honor, not the defendant.
It isn't. Oh. Well, let's see what's going on. All right, I closed the breakout room. For some reason, it's taking an extreme amount of time to get people out of breakout rooms. There we go. Okay, so let's go to the bond hearing then on People versus Sean Walaka. And that is file 215125SM. Mr. Travis is here on behalf of the defendant. Ms. Blue is here for the people. And sir, am I pronouncing your name correctly?
Yes, you are, Your Honor.
Okay, all right. So, Mr. Travis, are you familiar with the bond violations that have been alleged?
Your Honor, I believe I am, mainly from the docket entry. It looks like on April 23rd and 24th, there were reports from New Directions of positive PBTs. One is a 0.01 and the other is a 0.43.
0.048
0.048.
on 424. And I've also got a positive PBT on 518. It was a 0.019 and then a 0.018.
0.019 and 0.0. Okay. We did not
Yeah.
discuss that most recent one, Your Honor.
All right. So does the defendant wish to have a hearing on these, or?
Your Honor, yes, that is my understanding.
Okay. Well, you're going to want to talk to him then about the May 18th violations, an 019 and an 018. And before we go any further, I've got a note here also. The defendant was supposed to give us an updated address back on the 13th of May. And I just want to make sure we've got a good address for Mr. Walaka. So what is your address currently?
I did provide the courts with a change of address. It's a PO box number.
Your Honor, to that
Okay.
issue, we did receive information that he is still living with the victim. I have to confirm that at this time, but so I guess a reminder that he will be arrested if we catch him there.
Okay, well, there's another issue I think we need to take up, and I would like to hear when we come back any information you have about the defendant living with the victim, Ms. Blue, but we'll put the defendant back in a breakout room with his attorney for now. Okay, here comes that invitation again, Mr. Walaka.
But I don't think that could be. I think you can take the camera off until it's time for you to get on there. Is that him?
All right, I see Alicia Hall is on the line.
Yeah, Joey's here. Hold on. Sorry. It's Leroy Hall.
Okay. All right, thank you.
How do I turn that
We'll go
off?
ahead and get started as soon as I can see
Okay.
Mr. Hall.
Yep.
There he
Hold
is.
on. Go on. Sit down.
Yep, take your time. I'd prefer to have you seated somewhere.
Oh.
There we go.
Yep.
All right, so this is sentencing in the case of People versus Leroy Hall III. And Mr. Brott is here on behalf of Mr. Hall. Ms. Blue is here for the people. And Mr. Brott, have you had an opportunity to review the pre-sentence investigation report?
Yes, Your Honor. I do not believe, or I'm not aware, I guess, of any changes or corrections that need to be made.
Okay. And then what would you like to say on behalf of your client?
I guess I would say that at the time that this happened, Mr. Hall was staying with his sister. I believe he might be doing that again right now, but he hasn't stayed there the whole time. You know, I think it's clear that he's had some struggles with alcohol for some time. I do believe he was open and honest with the person doing the assessment. It's encouraging to me that his assessment shows that his recognition of the problem and a willingness to change, and that's reflected in the assessment scores. I think that his sister, when she reported the incident, even said at that time that it sounds worse than it actually was. I know that Leroy has done some jail time, I believe, when this case first started, and I believe he's done some since, because we had to adjourn the sentencing at one point because he was incarcerated down in Isabella. I guess what I would ask of the court is basically to give him fines and costs and give him credit for any time that he has served. And I do hope and believe that Mr. Hall will find his way into some form of treatment that works for him. I do believe that restitution has already been taken care of, but if the court wants to leave that open to verify it, that's fine. Mr. Hall may have some things.
Okay, thank you, Mr. Brott. So, Mr. Hall, is there anything that you'd like to say?
Well, I didn't have really anything pretty much prepared, but just off of I don't know, just pretty much just past history, and as far as that goes, you know, I do struggle a lot with a lot of things that go on throughout my life, and you know, every day is pretty much different, and still going through the court systems and having to deal with this stuff a lot, but you know, have been trying to take different steps and trying to get my life on track and stuff, and it's been difficult, but you know, I've been making progress and have my family behind me, and so I do have some sort of support, and me and my sister, we talk and stuff, so, and do a lot of family stuff with you know, my dad, who lives downstate and stuff, so my brothers and sisters, so we're pretty much just really good family orientated, and still try to do stuff even though we're all in different locations. But I would just like to say that I'm, you know, sorry for having to come through the courts, and for this to for it had to come to this to get back on track. And but I just, you know, me and my sister have a good relationship, and just, you know, we're working on things too, and it was just a mistake and accident, and you know, it won't ever happen again.
How long have you been, it looked like you've been sober for a while. Is that continuing?
Yes, I'm actually on bond right now for so I'm on bond right now for some stuff that happened down there with who I'm having a baby with, and it's just a continuous problem, and it's same thing, and it's, so at this point we're having a baby, but I had to leave her alone, and it's, you know, just to where my freedom means more than going to jail, and so yeah, so still on bond through Isabella, so still doing everything that I'm supposed to be doing and staying out of trouble as much as I can. And it's so right now I have court in a couple months for that. So yeah, so that's about it. And I did what I was supposed to do. Did my assessment through you guys. Referred me to do a assessment, so I did that and just trying to go through each little motion and everything that I'm supposed to do. So,
Are you testing through your other bond? Or your,
no, I'm not. I don't even live in that county.
where are you living currently?
I live here in Pashabitown.
Okay, because the report for some reason.
My
had you
my address right now
listed-
is currently in Grand Rapids at my dad's house, but I go back and forth between my dad's and to my cousin's Alicia's who I'm signed into right
Okay.
now on her.
All right, well, this is the deal. You got a terrible record here, and most of it's because you drink too much.
Mhm.
And, since 2011, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 convictions, 3 of them fighting with the police. You got drunk driving and disorderly conduct and fleeing police and B&E. So given the record here, the recommendation is jail time, and the easy thing to do would be to just put you in jail for the next 93 days. Okay, because that's what is called for with this type of record. And the rampage you went on, breaking your sister's windows, TV, laptop, smashed windshield. And then, you grabbed her by the neck apparently and shoved her into a car. Apparently she didn't want to go ahead with that, but it would be real easy to just say 93 days because that's what is deserved based on this conduct and this criminal record. And that would be the easy thing for you too. But what I'd prefer to see is maybe you get serious about trying to do something about all this. You got a child on the way, and you sound like a nice guy, and that's probably because when you're sober, you're nice, but when you're drunk, you cause all kinds of problems. So what do you think? Would you rather do the 93 days and get it over, or would you prefer to try to do a probation and address your alcohol problem and address your, they're recommending cognitive behavior therapy. And a lot of people I've heard say that they really got a lot out of that and it meant a lot to them. And that's what I'd like to see you do, because I have this feeling I'm going to just put you in jail.
I don't even.
And you're going to get out. You're going to be right back here.
In this county, though, that's the thing that I'm trying to get out of this area, so I can. I don't even be up here in Traverse City, so it's kind of hard when I have to keep coming. I'm trying to get this over with, and it's been a long going thing, and I'm process and having to pay my lawyer and make sure that I'm going out my pocket and having to do assessments and I served over 90 days, and that should have been ran concurrent. So from my understanding, that ran
from
concurrent
what I
because you guys had a hold
understand,
on me.
you've got 2 days in on this case.
I should have over 90 days, close to 100 days, and they said that was going to be counted towards this when I first got from transferred to Isabella, from Isabella to Traverse City. And from my understanding, when they have a hold on you, it just, I mean, that all goes to you, but it's, you know what I mean? It's something that you have to agree on, but I mean, they had a hold on me the whole time, and
He's
I'm
been
just
on a
trying to
PR
get
bond
this
the
over
whole
with.
time.
Yeah.
Looks like.
Yeah, the problem is you've been on a personal recognizance bond this whole time, so you haven't been getting credit for any of that time. And frankly, as a practical matter, you haven't, you did 2 days on this case. So I'm giving you a choice because the easy sentence here for me is just 93 days and be done with you.
Appreciate it.
In fact, the probation officer assigned you will probably curse my name by putting you on probation. But I see a lot of good things that you're doing. I see you work to get your GED, and you've been sober for a substantial period of time. And are you working right now?
I'm trying, and I'm working on I'm working on a lot of stuff. So this is like one extra thing I'm just trying to get over with, and just.
That's another thing. You'd be in a lot better shape to take care of your child if you got employed and started getting some money coming in. And
yeah, well,
so you want to eventually end up in Isabella County.
I can't even be there for the child, so I'm trying to work on myself right now, and I'm tired of being put in jail. So,
Your Honor, if I might, I think what
go ahead.
I think what Mr. Hall is trying to indicate is that prior to his even being arraigned on this matter, he had a hold on him while he was in Isabella County Jail. Not talking about the time he spent there in between arraignment and today. So he may be correct in that he may have that credit. I guess I wasn't aware that might be an issue, and so I didn't follow through on following up on that. But I think too, he's had a relationship with the mother of his child that's been a contentious one, I guess, and it's been on and off again, and there's been, every time things go bad, then she reports him as violating his bond and things like that. So he's been in and out of jail every time he goes down there to Isabella. So I think his plan is to try to live in the Grand Rapids area rather than up here. I think that's what he means by saying, I'm trying to get out of this area, because a lot of, he's been getting in trouble up here and getting in trouble in Isabella. And I don't think he's trying to run from his issues. I think he's just trying to find a stable environment where he can have better opportunities and be more stable than where he's been, either in Peshawtytown or in Isabella on the reservation there. So I think, I think he may be correct. I guess is what I'm trying to say with regard to the credit time. I don't know, but I can also see why the court wouldn't necessarily know without the information from the jail whether they had a hold on him before he ever showed up in 86th District for this case.
Can I add in one thing? When they transferred me from Isabella to here to Grand Traverse, the reason they gave me the bond was because I had in over the days. So they gave me a PR bond because I had in already like 102 days already. So when I got to Isabella, they automatically granted me a bond because they seen how many days I had credited.
Okay, well, this is what I'm going to do then. This is a major issue to me because it's sounding like the defendant does not want to be on probation.
No, that's not it.
He just wants to walk. Hang on, Mr. Hall.
Right, sir.
I'm trying to work with you here, but you need to stop interrupting.
Yes, sir.
One thing I don't think you understand is we do manage people in other towns. We've got people on probation all over the state. And we're able to come up with similar programs for probation in those other locations. Now, again, that's what I think would be the best thing, because I think you do show some potential here to change your behaviors and probably getting away from Pashabi Town, you know, maybe getting away from some of the negative influences, you know, with friends and things like that. Maybe that is a good plan. And so I don't have a problem with managing a probation in Grand Rapids, but right now I don't even know whether I'm able to sentence you to additional time in jail. I assume you wouldn't want to do probation if you really aren't looking at any additional time. So what I'm going to do is adjourn sentencing for today. I want to get that issue resolved. And Mr. Brott, you'll need to talk to probation. And if there is additional credit for time served, they need to update the pre-sentence report. But I want to know what the, you know, how the credit figure was arrived at, because just the fact that he gets arrested on some other crime, you know, if I've got a PR bond, I'm not convinced at all that I don't have that 93 days minus 2 to work with. And I wouldn't give him credit if he was on a PR bond here. A hold does not, well, that's different. Anyhow, we'll go ahead and adjourn this out. Ms. Odom, you want to pick a date at least 2 weeks out from today?
Mm-hmm. Sorry, hang on, let's get there. 2 weeks out, you said?
Yeah,
Okay,
and
where are
work
we
with
today?
Mr. Brott on finding a
Alright.
date that works for him.
Can you hear me off 10?
So that would bring us, Mr. Roth, that would bring us to Thursday, June 17th. Let me look here.
At present, I have that's the second day of a 2-day trial for me, Your Honor, that day.
You don't start.
Sorry.
Hello.
Okay, I'm
Hello?
sorry, I'm just waiting for.
Excuse me, whoever's on Susie's iPhone, if you could mute yourself until I call the case. I can hear you. This is,
Sorry, Your Honor, I have a conflict on the 17th. I have a second day of a 2-day trial that day.
Okay, let me check here.
Did you say mute my screen? Okay, sorry.
yeah,
sorry,
what's
sir.
your name? What's your name, sir?
Zar Quentin Quinn.
Okay. All right, yeah, we've got your hearing at 10 o'clock, so you're early. If you could just keep yourself muted until we get to your case, I'd appreciate that, okay?
Yes, no problem, sir.
Okay, thank you.
Okay, sorry about that. So how about June 24th at 9:30?
That will work.
Okay.
Okay, well, thank you, Mr. Brott, and we're all set for today. Mr. Hall, did you get that date and time?
Yeah, my pen's not working, but June 24th.
Okay.
At,
24th at 9:30.
Okay, got it.
Can you tell me where he is so we can rate him for this, if we need to?
Oh,
Mount Pleasant something.
He's in
so
Grand.
he
His mailing address is Grand Rapids, Your Honor. That's the best address to send him notice, and he's not in custody right now.
Oh, he isn't?
No,
Okay,
he is not.
sorry.
no, it's the address that's on the PSI.
Okay, thank you, Judge.
Okay, all right, thanks again, Mr. Brott and Mr. Hall, and I do think you should talk to Mr. Brott about my offer to consider probation, but we'll see what happens with the jail time, okay?
Yeah, I have no problem with that. I would just I'm just trying to get that clarified or something, because I'm just kind of confused and miscombobulated about everything, and Just get
All right. Well, I don't want to go into this with you confused about anything. So we're all set for today. Feel free to sign off. Let's go back to
Thank you, Honor.
Mr. Walaka. And Mr. Travis, have you now had an opportunity to speak with Mr. Walaka about all of the alleged violations? And does he wish to have a hearing on this?
He does, Your Honor.
Okay, so let's see. Ms. Blue, are you still there?
I am, Your Honor.
All right. Well, let's see. Did you want to call a witness, Ms. Blue? The court is accepting the reports from the agency as far as evidence of its case. But is there any other evidence or that you want to put on the record here?
No, Your Honor, we would just submit those exhibits as evidence and rest based on those.
All right. I do want to ask, apparently you've got some information about a violation of the no contact provision, and I was not aware of that. Is there information about that?
So the only information I have is a individual who let us know that at this point is not comfortable coming forward with it. So that's why, I don't think it needs to be submitted as a violation at this point, but we will be investigating it. So I guess if the court wants to let him know that if he is there, he needs to leave before he's caught there and arrested.
All right. So I won't deal with that as a violation today. Mr. Travis, do you wish to present any evidence?
We do not, Your Honor.
Okay, so what is the argument then, I guess? Why shouldn't I find that the defendant has violated his bond by testing positive multiple times?
Your Honor, it is basically just that we do not know why the tests are positive. We understand that they are positive, but we have no evidence to offer as to an error or a mistake or anything of that nature.
Okay, well, let's see, get back to Mr. Walaka's file. From the minimus, it's my understanding that the defendant has, in his past, he's been convicted of drunk driving third offense. And so there's a substantial history with alcohol. That's why the testing was put in place in the first place. We're testing twice daily with this also discretionary tests for alcohol. And the defendant has tested positive on 3 different occasions. And it's clear to me that he has a substantial substance use disorder because he knows he could, be put back in jail as a result of this, and he continues to drink. And I'm going to guess that alcohol was involved in the offense itself. Am I correct about that, Mr. Travis? Or is it alleged
Yes, Your Honor,
that he was
the report
intoxicated?
The report indicates that alcohol was a factor.
All right. This is what I'm going to do. Mr. Walaka, you need to comply with the conditions of bond. And just to reinforce that point, I am going to require that you report to jail within the next well, by 6 p.m. tonight. And you're going to spend 2 days there. And I will say this, that if you are violating that no contact provision, you've heard the prosecutors investigating that, but that's the most important of the conditions, is that you not have contact with the alleged victim. And if you're violating that, I'll put you in jail and you can sit there until the trial in this case. We'll put it on an expedited docket, but you're looking at some time out for that even. So
Your Honor,
fair
actually,
warning.
we're hoping to enter the plea, and I did discuss with Ms. Blue that that offer is still on the table.
Okay, what is the offer then?
It would be a guilty plea to count 1 under the deferrals handling and dismissal of count 2.
Oh, okay. So Ms. Blue, is that still an accurate statement of the plea agreement?
It is, Your Honor.
All right. And Mr. Walaka, is that your understanding as well? You'd be pleading guilty to one of these counts of domestic violence. I guess it's count 1.
Yes, Your Honor.
Yeah. And you'd receive the benefit of a deferred sentence.
Okay.
Okay. All right. So let me explain how the deferred sentence works. Now, I don't always go along with the prosecutor's recommendation, but I'd allow you to withdraw your plea if I didn't give you the deferred. Now, the way it works is you'd be placed on probation for a period of 1 year, or at least until you've completed all the conditions of probation, including a 36-week program through the Women's Resource Center called the Men's Program to help deal with anger management issues. And if you were to comply with all the conditions of the probation, you wouldn't typically do additional jail time, and you wouldn't have any conviction for domestic violence at the end of this. On the flip side, do you understand that if you do violate the conditions of probation, conviction for domestic violence may enter and you could get sentenced up to 93 days in jail?
Okay.
So you understand all that?
Yes, sir.
Okay, and Mr. Travis has answered all your questions to your satisfaction? Has Mr. Travis answered your questions to your satisfaction?
Yes.
All right. Has anyone threatened, forced, or coerced you in any way to get you to plead guilty, or have you been promised anything to get you to plead guilty that hasn't been discussed this morning?
No.
All right. I need to go over your trial rights with you and make sure you understand those before I'm able to accept a plea. So please listen carefully. You have the right to be presumed innocent unless and until proven guilty beyond a reasonable doubt by the prosecutor, and you have the right to a jury trial to make that determination. Do you understand all those rights?
Yes, sir.
You also have the right to have the witnesses against you appear at trial, to cross-examine those witnesses, and to present your own evidence and witnesses, and the court would order those witnesses to appear if necessary. Do you understand that?
Yes.
In addition, you have the right to testify at a trial, or if you choose, to remain silent, and that silence could not be used against you in any way. Do you understand that?
Yes.
And finally, by pleading guilty, you give up the right to appeal that you would have if you went to trial. And any appeal would be by leave, not by right, meaning it'd be up to the appeals court whether to even hear an appeal of your conviction or sentence. Do you understand that?
Yes, sir.
All right. Knowing all those rights, then, do you wish to waive them all in order to take advantage of the plea offer that's been made?
Yes.
All right. So turning to the complaint, it says here on April 10th, you were at an address in East Bay Township in Grand Traverse County on, looks like Ratio Road, and that you were with Braylon Waluka. Is that correct?
It's actually pronounced Waluka, but yes, sir.
Waluka. Okay. I was right the first time, I guess. Waluka. And how do you know Miss Waluka?
It's my wife.
All right.
Actually, Your Honor,
and,
that's Mr. Waluka, that Braylon is your son, correct?
Yes.
Okay.
I'm okay. So the plea is to count one, correct?
Correct.
All right. So, okay. So you were with Braylon Waluka and he is your son and a resident of your household, correct?
Yes.
So did you make an assault on your son, Braylon?
Yes, I did.
Can you explain what you did?
Apparently I got upset with him laying in bed in between me and my wife, and I asked him to move, and I grabbed his arms and dragged him down the bed.
Okay. And I take it he was upset about that, and you weren't acting in self-defense, correct?
No.
Okay. All right. Then to the charge of domestic violence as to Braylon Waluka, how do you plead?
Guilty.
All right. I will accept your plea, find it's voluntary, accurate, and understanding. We'll set this for sentencing at a later date. Ms. Odom, you want to work with Mr. Travis on that?
How about June 24th at 9:45?
Yes, thank you.
Okay.
Okay, so we're going to be back on that date. Prior to then, I do need you to get a substance use assessment and a pre-sentence investigation report. So I'm going to need you to contact our probation office about that, Mr. Waluka. I'll give you a number here. Let me know when you're ready to write that down.
Just one. Okay.
All right, it's 231-922-6899.
Okay, and that was for what now, sir?
Okay, that's our probation office. They're going to schedule an interview with you to get more information about what happened with the incident itself and your any other information that might be relevant for sentencing. Please call them after 1 o'clock today.
Okay.
That way they'll have the paperwork from this morning's hearing, but before 4:30 when they close, okay?
Okay.
All right, so, and we also need to get a substance use assessment so they can talk to you about that. All right, as for the bond violation, I am going to require that you turn yourself in, and it's going to be to the Leelanau County Jail. That's because the Grand Traverse County Jail is not taking short stays at this time, but Leelanau is. So you'll be reporting to the Leelanau County Jail in Suttons Bay by 6 p.m. tonight, and that's 2 days. You'll be out. What is it, Thursday? So you'll be out
Tomorrow morning.
Friday morning sometime. Possibly in time to get to work on time. Okay. All right. We're all set then for today.
Your Honor, may I
And,
ask something?
Go ahead.
Is there any way that I can report a little bit later than 6? Because I'm working out in East Jordan today.
East Jordan. What time do you get done with work?
It's been between 4 and 5 o'clock.
All right. We'll make it 7 p.m.
Okay.
That gives you over an hour drive time. So, all right, we're all set then for today. And did you put that 7 o'clock on that dispo?
Not yet, I will.
Okay. All right. So the dispo will reach 7 o'clock. And again, it's the Leelanau County Jail. Anything else, Mr. Travis?
Nothing further, Your Honor.
All right. Ms. Blue, anything else?
No, Your Honor, thank you.
All right. We're all set then for today. Feel free to sign off at this time, Mr. Waluka.
All right, thank you.
Yep, thanks. All right, let's go to People versus Matthew Howell. That is file 215197SM. Mr. Graff is here on behalf of Mr. Howell. Let's see. And is that Mr. Howell in the jail possibly?
It is, Your Honor.
Okay. There's a remote control there in the cell with you, Mr. Howell. Can you see if you can turn the volume on? I had to mute the jail because there's so much noise that comes from there. And if you're not able to get it, you can get one of the corrections officers to help you. Oh, it looks like you did it. Can you say something?
Hello.
Hi. Okay, I can hear you just fine now, Mr. Howell.
Okay.
All right. So this was a bond hearing, and let me see. The allegation is that Mr. Howell tested positive on May 8th, May 16th, and May 19th for alcohol, and also violated a no contact provision by going to 3765 Outback Drive, and failed to do a drug test on May 21st, and another one on, well, it says two different violations on 521, but I think it's just the one. All right. So, Mr. Graff, how would you like to address those?
Your Honor, it's my understanding Mr. Howell will be tendering a plea. I think back on the 24th of May when he was arraigned on these, he had indicated to the court that he wanted to enter a plea. And thankfully, the court, I think, originally sent it for the 10th of June, but it did get moved up till today. And so we appreciate that.
Okay. So, Mr. Howell, is that correct? You're admitting to those violations?
Yes, sir.
Okay. What are you going to do if I release you as far as where you're going to live?
I've been checking, well, I was checking into the Goodwill Inn. They were holding a room for me, and I was also checking into stay at my sister's house in town or just out of town, but I haven't talked to her because I have no way of getting a hold of her since I've been in here.
All
So
right.
I'm relying on getting a hold of the Goodwill Inn and having them set me up with, I don't know, a situation there. I'm not exactly sure how that works there.
All right. What about testing positive? Are you going to be able to conform yourself to the rules here? You can't use alcohol?
Yes, sir.
All right. Ms. Blue, do you have anything for the people?
No, Your Honor, thank you.
All right. This is what I'm going to do then. I will release you upon you providing a valid address where you're going to stay that is not 3765 Outback Drive. So you'll have to get on the phone and talk to, I think you said your sister possibly, or the Goodwill Inn, and verify that they're willing to take you so the jail knows that that's what you're going to do. Okay? But I don't want to just release you and have you not have somewhere to stay. And then just go back to Outback Drive there. So anyhow, anything else for you, Mr. Graff?
No, thank you, Your Honor. I guess, how exactly does the court want that information? So I don't want to fall through the cracks. Is that, did the court depend on me, or is it possible if Mr. Howell just provides it to the jail and have it sent to the court, just so we make sure?
Yeah, provide the address to the jail and have them, and they'll get it to the court so we know where to send notices in the future. And so that we know he's not going to be back at the Outback Drive address. Ms. Odom, did you have a question?
I do. So you're going to release him. Do you want to reinstate his original bond that was set on April 27th, 21? It was a $5,000 PR bond with conditions.
Yes, we'll reinstate the original bond with all the same conditions. You're going to have to test at New Directions or somewhere else until you get your Smart Start set up again. And so that's it for today. Unless there's anything else, Mr. Graff?
Yeah, I guess just to clarify, I think the original bond, it might have been twice daily PBTs. Since that time, it's my understanding it was amended to 3 times a day. I just want to make sure that Mr. Howell obviously is testing appropriately and not confused about his testing regimen.
He's correct, Your Honor.
Okay, so it is 3 times per day. The good news is it doesn't cost you any more if you test once or 10 times a day on that Smart Start device. And I will allow the Smart Start. Defendant's obviously using the device, but still drinking. And so anyhow, that is the sentence. And
he does have times, and nobody was able to get in touch with him back on
oh,
5/20.
okay. What are the times he's supposed to be testing?
Sure. 5 to 8 a.m.
From 5 to 8 a.m.
5 to 8 p.m.
5 to 8 p.m.
Sorry, this is out of order. And a 10 to 12 a.m.
And 10 to 12.
What isn't out of order? Okay. So 10 p.m. to 12 a.m.
10 p.m. to 12 a.m.
Yeah.
Okay, till midnight.
Yeah.
All right, so those are the 3 times. And given all that, I would also require on release, you need to contact our bond clerk, and and that way they can go over all the bond conditions with you and make sure that you're aware of them all, and that'll keep you out of trouble. So so make sure you do that as well.
Get into trouble.
Okay, we're all set then for today. And
Can I ask one question?
Go ahead.
I'm doing UA testing 8 times a month, and I have never tested positive for that. I don't understand why it's so much. I have never been around drugs in 30 years, and they are having me do that 8 times a month. They were having me do that.
Okay, Ms. Blue, any concerns about the drugs? It does indicate here that he has always tested negative in this case, although he did miss a couple. Well, he missed the test on May 21st. Were drugs involved in this case?
I don't believe so. My only concern would be if the addiction would shift then to some type of substance, but I don't have anything referencing drugs being an issue in the case.
All right, it does say twice a week, which is very unusual given no history of drug use. So I'm going to change that. We'll make it discretionary only for drugs. Okay, and that's it. All right, we're all set for today unless there are any other questions.
Nothing, Your Honor.
Do I talk to my attorney afterwards by myself?
Yes, you can give Mr. Graff a call and he'll answer any questions you have, okay?
Okay, well, I'll be right here. Thank you, Judge.
Thank you, Your Honor.
Okay, thank you.
Pick up.
All right, let's go to people
Well, how am I
versus.
supposed to get a okay. That's that.
I'm gonna mute jail again. All right, so let's go to people versus Quentin Quinn. That's file 214875SM. Mr. Kane is here on behalf of Mr. Quinn. And Mr. Quinn, are you still with us there?
Yes, sir. I had to unmute it.
Okay, thank you. And let's see, this is the date for a plea. Mr. Kane, has there been a plea offer made?
There has not been a plea offer made, Your Honor. Nonetheless, Mr. Quinn is going to plead guilty to the charge.
All right, is that correct, Mr. Quinn? You want to change your plea to guilty?
Yes, sir. I'll admit my immaturity mistakes.
Okay, I'm having some difficulty hearing you. It sounds like there's some problem with your phone, maybe. I can't see you either.
I can speak a little louder. I'm sorry, sir. I said yes, sir. I'm gonna plead guilty. I apologize for the immaturity of my mistakes.
Okay, well, I wish it were that simple, but there's some rights I need to go over with you before I'm able to accept your plea. So please listen carefully, okay?
Yes, sir.
All right. Have you been threatened, forced, or coerced in any way to get you to plead guilty, or have you been promised anything to get you to plead guilty?
No, sir.
So it's your own free will to plead guilty today?
Yes, sir.
Has Mr. Kane answered all your questions to your satisfaction?
Yes, sir. He's been here with me the whole way, and he has me more. I've been aware of everything and understanding from the jump.
All right, very good. So I need to go over your trial rights with you and make sure you understand them before I'm able to accept a plea. So please listen carefully. You have the right to be presumed innocent unless and until proven guilty beyond a reasonable doubt, and you have the right to a jury trial to make that determination. Do you understand all those rights?
Yes, sir.
You also have the right to have the witnesses against you appear at trial, to cross-examine those witnesses and present your own evidence and witnesses, and the court would order those witnesses to appear if need be. Do you understand those rights?
Yes, sir.
In addition, you have the right to testify at a trial, or if you choose, to remain silent, and that silence could not be used against you in any way. Do you understand that?
Yes, sir.
And finally, by pleading guilty, You give up the right to appeal you'd have if you went to trial. Any appeal would be by leave, not by right, meaning it'd be up to the appeals court whether to even hear your case. Do you understand that?
Yes, sir.
All right. So knowing all those trial rights that you'll be giving up by pleading guilty, is it your desire to waive them all and enter a plea?
Yes, sir.
Okay. Do you understand that by pleading guilty, you'll have a conviction for retail fraud, 3rd degree, and that carries a maximum penalty of up to 93 days in jail?
Yes, sir.
All right. So now I need to establish that there are facts that to show you did commit a crime. So is it true you were at the Easy Mart in Green Lake Township in Grand Traverse County on February 24th?
Yes, sir.
And did you take some property that the store was offering for sale and try to leave without paying?
Yes, sir.
Do you remember what it was you took?
Yeah, it was a cigarette. Like I said, like no excuses here or none. You know, I had some items that I did, purchase on my own, and then I came back in, and I forgot my ID in the car, whatever, and just walked out like pretty much the items, and meant to go get it, and I figured since I like got outside with it, which is a childish move, that like, that I could pretty much, like didn't have to go back in, which is, what I'm saying, was just stupid. Whatever.
Mr. Quinn, again, I'm not hearing you very well.
I'll take my right for that and whatever. So be a man.
All right, Mr. Quinn, I can barely hear what you're saying. If you could be more careful with your phone and how you're speaking into it, I would appreciate that.
So, Your Honor,
it's just my speaker, man.
The items taken were some Rice Krispie treats, a sausage link, and some kind of, it says gravity fee, 33-cent item. Total value was less than $5.
Okay. Thank you, Mr. King. All right, then to the charge of retail fraud, 3rd degree, how do you plead, Mr. Quinn?
I'm guilty. That's true. Those items were taken. They were
okay. I will accept your plea and find that it's voluntary, accurate, and understanding. So, Mr. Kane, Mr. Quinn's name is very familiar to me, and that's usually not a good thing, because it usually means there's some.
He does have a modest record. Some of it, I think, was acquired in your past existence as the prosecutor, but some of it's a little more recent. He's got a juvenile adjudication from a while back, a 2017 conviction for failure to report an accident to fixtures, a 2018 conviction for domestic violence, and a 2019 conviction for possession of marijuana before it was made legal, as well as a reckless driving conviction. So those are on his record. That is true. He does have a record.
All right. So what are you recommending I do in this case?
Well, Your Honor, you're aware of the record. You're aware of what he's taken. You've also heard his allocution that he's been acting immature. He knows he needs to man up, to use his words. I agree with him that the time for kid stuff is over. He's been through the system long enough to realize that this kind of behavior, it can't be condoned. I'm respectfully requesting maybe a brief period of probation if the court is disinclined to assess fines and costs, if for no other reason to supervise him and ensure that he's behaving for the short term. I would remind the court that the not that it's an excuse or that it is justification, but the items that were taken amounted to less than $5. And again, I'm not trying to downplay the importance. It exemplifies just what he said: immaturity, and maybe a little bit of laziness. If you walked out of the store and didn't feel like walking back in, well, you can't do that. So if it's not a fines and cost case, perhaps the retail fraud therapy class, maybe some community service to underscore the point and hammer home that he's old enough now not to be doing kid stuff. He's gotta be old.
Okay, Mr. Quinn, is there anything you'd like to say?
If it's okay with, yes, sir. It's like, yeah, what Steve was saying. I would just like to let you know, even out the act of, the childishness that I did, it's more irrelevant because I know better, because I'm mature of a man, and so it's more stupidity that that I would know better to make a decision like that. So there's no excuses, and I was like, let you guys know, any punishment that I was served in this case, dude, I don't judge, I don't mind it. It's I don't blame you guys, and I can handle my stuff, like a man, like I deserve to. It's something that I know better than, and I don't mind. I don't blame that on anybody else for my actions, So I was like, let you guys know that I would like to, man up off of that and keep pushing, forward in life on those mistakes and make sure, it never happen again, and be a role model towards, the young ones in my life, and make sure, that they don't see a picture of me like that or whatever. And that's what I have to say. So, I apologize to myself and, the store, and also you guys for those actions. And, no excuses here. So sorry about that. And, what goes on
Okay.
here.
All right. Thank you, Mr. Quinn. Well, oh, go ahead. Were you done, Mr. Quinn?
Yeah. Just one more thing. Probably just like to the record, back, on my record ever. I've had, probably, a lot of growing up, a rough time, man, trouble and stuff. And I'm not trying to minimize the situation or nothing. It's been quite a few since I've, been until this case, since I've been in trouble, and you guys, county, Grand Traverse, it's been quite a bit of hour, it's not trying to say I'm minimizing or whatever, because if that was the case, I wouldn't be where I'm at right now. But, just letting, I'm letting you know that I'm really upset with myself, because, in my eyes, in my opinion, not saying that it's everybody else's choice, but in my opinion, I really thought that I didn't got my act together for quite a bit. And, that kind of threw me back down and made me look at myself in the mirror too.
Okay, thank you. All right, well, this is what I'm going to do. The facts are defendant stole some food items at the Easy Mart in Green Lake Township, and the total was actually $3.61. Defendant stuffed the items in, or at least some of the items, in his waistband to conceal them. And so that's the offense itself. The defendant does come to the court with no prior record of being a thief, but he does have a record for domestic violence, and I think there's 4 prior involvements with the law before this. So I think that given those facts, the a period of probation does make some sense. So what I'm going to do is place the defendant on a 6-month probation. And Mr. Quinn, you can request to have supervision terminated after 3 months if you've completed all the conditions of that probation. So the conditions are going to be that you not go to the Easy Mart in Interlaken. They wanted you trespassed anyway, so you're not to go there. In addition, 3 days of community service work. And this is the deal. If you don't do the 3 days of community service work, it's going to be 6 days in jail. Okay?
Okay, sir.
That's because jail's a lot easier than community service work, frankly. So it's 6 days, not just 3. And then let's see, the other conditions are going to be that you be respectful of all court employees and care providers, and you complete our retail fraud class. And that's it.
Fines costs.
Fines and costs are going to be $75 fine, $100 costs. There will be a $75 Crime Victims' Rights Fund fee, $50 judicial system fee, and Mr. Kane's service is $250.
The restitution.
Oh, there's no restitution because the report indicates the items were recovered. Okay, so this is what I need you to do, Mr. Quinn. To follow through with this, you're going to need to contact the probation office after 1 o'clock today. Have you got a pen handy where you can write a number down or maybe put it in your phone?
Yep.
Okay, this is the number to call. It's 922-6899.
922?
Yep, 6899.
Okay, thank you.
All right, call them after 1 o'clock and they'll set up, they'll talk to you in more detail about how to get that community service work done and the other conditions, okay?
Okay.
We're all set for today. Please feel free to sign off at this time, okay?
30.
Thank you, sir.
Thank you, Mr. Kane.
Judge, we do have somebody from the magistrate's office. I don't have a good view. I don't know if Mr. Vardaville is there.
There I am. Can you see me now?
I can. I don't know if you want to take that yet, but I just want to make you aware in case there's a hearing that goes into probation violation.
Okay.
And his name is George Vardaville.
All right. Well, I do have Mr. Newman here. And let's see, I don't have a Newman on my docket, so I want to make sure.
Here, let me look.
Are you here
Mr.
for,
Newman?
what hearing are you here for, Mr. Newman?
We are here for Barterville.
Oh, you are here for Barterville. Okay.
Correct.
All right. So we'll go ahead and take that matter up next. Mr. Hunt, are you also here on Barterville?
Yes, Your Honor.
Okay. And I take it that's Mr. Barterville with the fan going above you in the glasses?
Yes.
Okay.
Yes.
I'm going to rename you. What's your first name again?
George Anthony. I'm typically called Tony. You may find that in some of the references.
Okay. All right. I'm going to take a moment to get some more information about the case before we get started. So it'll just be maybe 10 minutes here.
He failed to appear for his plea.
Oh, is that what it was?
Yeah, he failed to appear for his plea on 4/29. That's all I see in here.
Okay. So is that the reason we're here, Mr. Hunt, for the fail to appear for the plea?
Yes, Your Honor. I had contacted the court and set up a time for an arraignment on the bench warrant, and we appeared in front of the magistrate, and then we acknowledged that he did not appear, and I explained the reason on the record at that point, but then they said we would have to come in front of you.
Okay. So All right. Is he intending to enter a plea today?
To the underlying charge, the actual charge on the offense?
Yes.
I don't know that we can, Your Honor. Charlie Hamlin actually, but the original, at one point there was an attempt to do a plea, then an issue came up about the possible sentence that would be involved because this is an attempt of a felony offense. And there was a question about jail time. And that was discussed last time when Tony was not in court. And I know Mr. Hamlin is going to have a position about that as well. So I'm not sure that we can do the plea today until we get it resolved about the sentencing, about the possible sentence.
Okay. All right. Well, let's just deal with the bond violation then. Why is it that Mr. Bartaville didn't show up for the last hearing?
He was in jail in Antrim County, Your Honor. He had gotten arrested the night before. It's actually an OWI 3rd. So he was in jail that morning, did not get out for a day or so after.
Okay, so apparently we weren't aware of that at the time.
No.
I assume. So that's a pretty good reason for not being present at our hearing, at least. So I will recall the bench warrant, and it sounds like what we need to do. Does it make sense to reset this for a plea, Mr. Hunt, or another pretrial with the prosecutor, or how do you envision going forward?
I am assuming it needs to be set for a plea, Your Honor. The agreement is set of what he would plead to, but the issue that came up at the last hearing was what the potential penalty would be, because you had believed that it cut everything in half because there was a mandatory minimum on the original felony charge.
Okay, now it's coming back to me. So did you provide a brief to me on that, or are we just going to argue it on the record?
I don't recall if I actually did a brief. I know that I had gone back and talked to Mr. Hamlin about the statute, and I wrote a letter to him. I will have to check to see if I sent something to you, but I can do that, Your Honor.
Okay, and obviously the drunk driving third offense, has he been charged with that offense?
Yes, Your Honor, that's in circuit court right now.
Okay, so Mr. Bartaville may have bigger fish to fry even, or at least that could have a significant impact on this case as well. So what we'll do is set it for a plea then. Do you think a week is enough?
I am assuming so, Your Honor. I don't know what your anticipated date would be.
Okay, Ms. Odom, you want to throw out some dates here, and I want to make sure the Newmans are able to attend as well. I know they're interested in this case, so let's make it sure it works for them.
Okay, so Monday, June 14 at 10:30.
Can I speak, please?
Yeah.
Sure, go ahead.
If I could have a couple of weeks, I've got a very busy couple of weeks going. I'd like to consult with Jim about some of the what ifs of this case and whether I'm going to plead to 2 charges on this. And I really would like a little more time with my attorney, Your Honor, if I could. And I won't be able to see him till first of next week, probably. If I could have another several days after that, that would be wonderful. If not, then so be it. I'll make it work. Thank you.
All right. Well, Mr. Hunt, do you have anything you want to say about that?
No, Your Honor, I do need to talk to Tony, but the 14th would be a week from Monday. Are you asking for more time than that, Tony?
Well, I mean, if it was available, great. That way I have some time to consider my options and if they're gonna be take this to a jury trial, then getting some money around. So.
All right. Well, these are significant decisions that the defendant needs to make, and I don't want to. It may be better all around if everyone is fully informed before we get here the next time, because I think we need to resolve some issues here. Either we're going to go to trial or there's going to be a plea. So can you go out a couple days past that?
The next date I have available is Tuesday, June 22nd at 10:30.
That's the soonest, huh?
Mm-hmm. Well, I mean, we can always stick them in somewhere, but we're pretty busy. Let's see. And that's 1, 2, 3, 4, 5, 6, 7. That's 7 days, 8 days after the 14th.
Okay, Mr. Hunt, does that date work for you?
The 22nd?
Yes.
Yes, that would work. Is that 10:30? Or I don't know what time?
Yeah, 10:30.
All right, and Mr. and Mrs. Newman, is that time going to work for you?
Yes. May I have something to say here as named?
Sure. Go ahead, Mr. Newman.
Okay, I have 2 points. Number one, we've been following these hearings since before this year. We have seen many people appear at hearings from the jail, so we don't understand why he's using the excuse that he couldn't show up because he was in jail. And he's dragging his feet. This has been going on now for a long time. That's all I have to say.
All right. Well, I appreciate your frustration. The reason he wasn't able to appear from the jail is we simply didn't know that he was in jail, or we would have set that up. That's a more common problem than you might think, that someone's arrested in another jurisdiction and we're just simply not aware of it. So if we had known that, we certainly would have had Mr. Bardaville there from the jail in Antrim. So I appreciate your frustration with how long things are taking, but the other thing I would note is that if this does go to trial, it's unlikely that we're going to start trials until mid-July now. And there's a backlog of cases because of the pandemic. And as a practical matter, if it does go to trial, it's going to be a while before that happens. And that's because we have orders from our state court administrator's office that we can't hold jury trials right now because of the positivity rate in Grand Traverse County, which may seem unusual given that seems like everybody's masks are coming off and we've got so many people vaccinated now, but that's where we're at. I do think that we could get here on the 14th, and if Mr. Bardaville is still trying to get questions answered by his attorney, we may all be wasting our time and spinning our wheels. And so I think giving Mr. Bardaville a few more days to figure this out, what he wants to do, makes some sense. And but on the 22nd, we may need to have a decision here, and I need to know whether you agree with the prosecutor about the potential jail time, and we'll get all of those issues resolved then. So again, Mr. Newman, I understand your frustration, but we'll hopefully have more answers on June 22nd. So All right. Yeah, go ahead, Miss Odom.
Okay, so since there's a bench warrant, his bond was revoked, so do you want me to reinstate the 1/5/21 bond with all the terms?
Yeah, we'll go ahead and reinstate the original bond in the case. I'm sure there are additional bond conditions now with the Antrim County case. And so I'm going to add a further condition that he comply with all of those conditions as well.
Is that a circuit court case?
Yes.
Yes. Okay, we're all set then for today, and feel free to sign out at this time.
Thank you, Your Honor.
All right, we're going to go on to People versus McNeil. Is Patrick John McNeil present?
Yes, I am, sir.
Okay, good. Give me a minute to rename you. All right, and Mr. Johnson is here on behalf of Mr. McNeil, Ms. Morton for the probation office. And this is the date set for a probation violation hearing. Mr. Johnson, have you discussed this with your client, and what does he want to do this morning?
Yes, Your Honor, thank you. I did have the chance to speak with Mr. McNeil. He has indicated to me that he would like to have a hearing on this. However, he is asking to proceed representing himself.
All right, so Mr. McNeil, you want to represent yourself in this particular hearing?
Yes, sir.
Okay, and you obviously understand that you do have a right to an attorney, and the court would appoint one at public expense if you were unable to afford one.
I do.
Okay, and you want to waive your right to the attorney, but proceed with a hearing, correct?
Well, if I could talk to him, I haven't talked to him or spoke with him in a week since I've been had a violation. So, but there are some other things going on. I'm sorry, go ahead.
Well, let's go ahead and put you in a breakout room then with Mr. Johnson.
Yes, please.
Because it's unusual for you to want a hearing but not have an attorney involved. And probably a foolish decision as well. But anyhow, so I'm going to put you in that breakout room and make sure you accept the invitation that pops up on your device. I'm going to be in recess. We'll come back in about 10 minutes here.
I'm
Where's
here.
the live, just so you know.
Okay, I'm here for Yarmouth hearing, but I have an appointment at it was scheduled for 10:45. I think I have an 11 o'clock appointment.
Is Guillermo here?
I don't know.
Mr. Yarmouth, are you here?
And I don't know. I'm Mr. Hubble.
Is Hubble, did he ask for a lawyer?
All right, it is 10:45. I don't see either of them.
Well,
Let me go back on the record here. Hang on.
You said you have an appointment right now, or you have an appointment at 11?
At 11.
Oh,
so I
okay.
can wait. It's no problem.
Yeah, if you want to wait a few minutes here and see if they show up.
Okay.
And if, let's see.
Hubble was appointed.
We'll see if they want a hearing or not, so.
Okay.
All right. Okay, thanks.
Thank you. Great. I'm gonna get back downstairs.
Okay.
I'm having technical difficulties just now.
Where?
Well, I didn't bring my own laptop in because I forgot I had two hearings. So then I quick installed Zoom on my desktop.
Oh, that's why you're in here, is
But
what
I
you're
don't have
telling
a
me.
speaker. I have a microphone. So then I went and got a laptop from Heidi that doesn't have Zoom on it either. So I'm like, okay. So then I ran up to Judge Douglas because I went in his courtroom first to just sign in on the computer there. There's no mouse. So I'm like, I don't know how to make this. I mean, I know there's a way to make it work, but I don't know how to make it work.
It's always have a mouse. I wonder when that.
I'm just gonna
There's Mr. Yarmouth, I think. Are you Mr. Yarmouth?
Yes,
Have you spoken with Mr. Hubble?
a little bit. I
A
was
little
just
bit,
on the
Mr.
phone.
Hubble?
I was just on the phone with him.
Okay, so he should be signing in any moment.
Yeah, I just hung up.
Okay. We had that kind of a day yesterday, a little bit. Kind of. Our printer didn't work. Hi, Mr. Hubble.
Hi, Miss Odom. How are you today?
I'm doing okay. I'm doing okay. Thank you. And you?
I'm well, thank you.
Well, good. So are you ready to get going on the probation violation?
We are. He's going to be taking responsibility for the probation violation. Obviously, he'd like to offer his explanation for what happened, but he will be pleading guilty.
All right. Thank you. Let me let the judge know.
Thank you.
Mr. Yarmouth and Mr. Hubble are here, and they want to take, he wants to take responsibility for it.
Willie, are we ready or do you need to still talk with me?
So do I just tell him?
No, we're on, everything's being recorded, so. Text me.
Okay.
Hello. Oh, this is Mr. McNeil. I didn't know if I took a minute to get back in.
Patrick, we're just waiting on the judge, okay?
Oh, I'm sorry. Yep. Apologize.
You're good.
Ms. Foden?
Wash my hands and walk away.
Your Honor.
Yeah, who's this?
This is Paul Hubble.
Oh, hi, Mr. Hubble.
I'm sorry, I guess I would like to see if I can go into a breakout room for a few minutes with my client. He did want to try and discuss something before we go on the record. I believe it will be handled the way I discussed, but looks like you have some other people waiting in the wings, so.
Yes, I do. I guess I'm looking for your client. Is that
he's on the
Mr.
iPhone?
Yarmouth? He's on the iPhone, okay. So let me rename him first. Okay, and I'm going to put you in a breakout room, Mr. Yarmouth.
Okay.
With your attorney, and we do have, I think, just the one hearing before yours, or maybe there's a couple.
Thank you, Your Honor.
Okay, thank you. All right, so Mr. Johnson, are you going to be representing your client at this point, or does he still want to represent himself?
Your Honor, I would be representing him at this point, and this would be an admission.
Okay. So, Mr. McNeil, is that correct? You want to take responsibility for the probation violation?
Yes, sir.
Okay. All right. And again, you do understand you have a right to a hearing to contest the charges being made, and you want to waive that right.
Well, this is a probation violation hearing right now.
Right, but you do have a...
But I do understand that, yes.
Okay. All right. So is it true you were placed on probation for domestic violence back in February of 2020? And as a condition of that probation, you were supposed to take preliminary breath tests and drug screens as ordered. And you tested positive back on April 21st for alcohol. Is that true?
April 20th, yes, because I turned myself into jail. But yes, that is true.
Okay. And then it also says you missed your AMPBT on that date as well. Is that true?
I believe not, no.
It's just the one test then.
Well, I do 3 a day, and I did all of them, and then I was sentenced to 6 days in jail, and I did all my breathalyzers that day, and then I turned myself in, and I was drunk when I turned myself into jail, yes.
I see. Okay. And then it also says on April 25th, you tested positive for alcohol. Is that true?
It is not, and that's why this is why my denial, this is the denial of probation violation, because I tried to blow in my machine at, my 3rd test, and it kept saying I was failing, and I just got out of jail that day, and so that's why this is occurring.
All right. Well, we're going to adjourn this, well, not adjourn, but I'm going to go to a couple other cases here before we take up a hearing in your case, because I'm not going to do this piecemeal. We'll get some testimony from the probation office, and you'll be allowed to present your own testimony if you wish, and any other evidence, and then I'll have to make a decision about whether there were these violations or not, okay?
Yes, sir.
All right, so just sit tight, and let's go to well, let's find out what's going on with our preliminary examination. So this is file 215249FY, People versus Jonathan Cook. And Mr. Warden is here for Mr. Cook, Mr. Hamlin for the People. And let's see, is Mr. Cook on the line somewhere?
Yeah.
All right, Mr.
Yeah,
Cook,
can
are
you hear
you
me?
able? Yes, I can. Are you able to turn your video on? Do you have video?
No.
Okay, well, we'll have to proceed in this fashion. So, Mr. Warden, this is the date for preliminary examination. What does your client wish to do?
This would be a waiver, Your Honor.
All right, so, and you've discussed the purpose of the hearing with Mr. Cook, and that's what he wishes to do as well.
That's correct, Your Honor.
All right. Mr. Hamlin, are the People agreeable to a waiver?
We are, Your Honor.
And Mr. Cook, that's what you want to do after speaking with your attorney, is waive your right to a hearing.
Yes, sir.
All right, so the examination has been waived. The defendant is bound over to the circuit court to appear next on June 18th at 1 o'clock. And that is for the circuit court pretrial. Are there any issues as to bond at this time?
No, Your Honor.
Not that I'm aware of, sir.
All right, so bond is continued. Let's go to the circuit court arraignment.
Thank you, Your Honor. We would waive a reading of the felony information. Mr. Cook is aware of the charges pending against him, the maximum penalties, and would ask the court enter not guilty pleas.
All right, I will enter not guilty pleas on the defendant's behalf. And is there anything else we need to take up this morning?
Not from defense, Your Honor.
Nothing from us, Your Honor. Thank you.
All right, thank you. And we're all set. Mr. Cook, feel free to log off at this time.
Well, thanks. Have a nice day, gentlemen.
Okay, let's see if Mr. Hubble is, well, it looks like he's still talking to his client. Let's see, is Mr. Johnson still there?
I think they are, probably in the background.
I don't think so. Looks like we lost Mr. Johnson and Mr. Yarmouth.
Okay, that's odd.
You want to send him an email and find out what's going on?
You know, you used the word adjourn at one point. I wonder, and I know you corrected yourself, but I wonder if that's what he thinks is going on.
Is Mr. Yarmouth there? Maybe they thought I was gonna take more time with those other cases, so they're gonna tune back in.
Well, that could be, but it's kind of odd. Who's that?
Mr. Cook.
Oh.
All right, Mr. Johnson, do you know what happened to your client?
I'm here, Mr. Your Honor, I'm here.
Oh,
Mr.
you
McNeil's
are?
here. Yeah. I can hear
Oh.
everything's going on. I'm sorry.
Oh, okay. I've got you labeled as Mr. Cook for some reason, so.
No, I don't want to be Mr. Cook. Maybe I do. I don't know. But no, I'm here. Your Honor, I've been waiting.
Okay, great. All right, so Mr. Johnson, I guess, are we going to go ahead with the hearing then at this point?
It sounds like if Mr. McNeil is not going to admit to all of the violations, then I guess we would need to go through with a hearing. Yes, Your Honor.
All right, so let's go ahead and get started with that since Mr. Hubble is still tied up speaking with his client. So Ms. Morton, if you could please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth?
I do.
All right, so is it true Mr. McNeil was placed on probation on February 27th, 2020 for a domestic violence conviction?
Yes, Your Honor.
As a condition of that probation, is it also true that Mr. McNeil was ordered not to use or possess alcohol
Yes, Your Honor.
or certain substances as well?
That's correct.
All right. And he was also ordered to test for alcohol on preliminary breath tests and urinalysis for drugs. Is that correct?
Yes.
All right. Was there a test that was ordered on April 21st that was missed by the defendant?
I'm just going to correct him a little bit. After hearing him this morning, I double checked with Leelanau County Jail when we took the break. I will like to correct with Mr. Johnson's report. The first violation should be 4/20 of 2001 when defendant turned himself into Leelanau County. He had a positive PBT of 0.177, according to Leelanau County Jail. I will ask to strike the violation of the missed PBT on 4/21 as he was in jail. Other than that,
okay.
The 4/25 violation that he is saying he was in jail, he took his PM PBT. I sent evidence to Mr. Johnson as well as to yourself that he took that PBT on 4/25 in the PM with the positive results. He was released from jail on 4/25 at 05:21 hours. Mr. McNeil really was gone the first year of his probation. Finally was picked up on a warrant or turned himself in. That's when he had court for these violations on April 20th, where he served those days in jail. Once he got out, he was given new paperwork to begin his substance abuse at Munson Behavioral Health, to start his community service, to go back to the men's program, and to report to probation. Those are the other violations he failed to report in May. He has failed to return any of his signed probation paperwork back to me that was given to him. I have no proof of him attending Munson Behavioral Health since getting out of jail. No proof of community service. I was told that he did have an intake with the men's group, but he missed May 17th and May 24th. So those are the violations. And he failed to do his urine screen on May 22nd. And I have provided evidence of those missed testing as well as the missed men's program. Mr. McNeil was told, I emailed him asking him for those paperwork. He asked how he was supposed to sign it and return it. I advised him and I never heard back from him.
You may have addressed this, but I missed the May 22nd missed urinalysis. Do you have a record of him missing that test?
I should, yes. Let me look. Yes, May 22nd, he was a no-show for his morning urine screen.
Okay. All right. Mr. Johnson, do you have any questions for Ms. Morton?
I do not, Your Honor.
All right. So is there any evidence you'd like to present?
I would like to allow Mr. McNeil to testify.
All right. Mr. McNeil, are you able to turn your video on?
No, I'm not, sir.
Okay. All right. Well, please raise your right hand and tell me when you have done so.
I've done so.
Okay. Do you swear or affirm that the testimony you're about to give will be the truth?
Absolutely.
All right. you can put your hand down, and Mr. Johnson, go ahead.
All right, Mr. McNeil, on April 20th, you were ordered to turn yourself into the Leelanau County Jail. Is that correct?
April 20th, yes.
Okay. And prior to your arrival there, you did consume alcohol. Is that correct?
Yes, I did.
Okay. And then you were released on April 25th. Is that correct?
Yeah.
And that evening, you were required to do some PBTs. Is that correct?
I did my morning PPT, my afternoon PPT, and I tried to do my third PPT, and it kept saying I kept failing. That is correct.
Okay. And as far as you are aware, what were those failures due to?
I have no idea. It just kept saying I was violation. It gave me 3 of them. So, and then it turned the machine off. So I'm not real positive why.
Prior to taking those tests, had you consumed alcohol?
I have not.
Okay. On May 22nd, did you miss a morning urine screen?
I did.
Okay. Did you fail to report to your probation officer in May?
Yes, I did.
And why did you do that?
Well, because they violated me on the 20th, and I just kind of stopped doing it all again for like the 3rd time. So I don't.
Okay. And so then you would agree that later in the month of May, you did fail to return the signed probation paperwork?
Yes, I did.
And you failed.
I did fail to return them. Yes, I did.
Okay. And you did not provide proof of attending substance abuse counseling?
Actually, I did 2 classes of that, and I did do my behavioral men's class at Munson, but I did not send it in.
Okay. Did you complete what was required of you there?
I believe not, apparently, because I'm being questioned for that. So
okay.
I did 3 classes. I did 3 classes at Munson Behavioral Health, and I did 2 classes for whatever the other one was there. I'm not sure, substance abuse or whatever that is. I did 2 classes there, and then I'm not even home from work at 6, so it's hard to do. I'm sorry.
Okay. And on the same date, you did not provide your probation officer with proof of completion of community service work. Is that correct?
No, because I called Catholic Human Services to get community service, and they opened just 2 weeks ago, and I was trying to set it up, but then I just let everything go. So that is honest. Being honest.
Okay. And you let everything go because of your work schedule. Is that correct?
Well, my work, and then I have a CPS case going on, and it's just a lot of stress on me, and I don't know. I can't do all of the requirements everybody wants me to do, plus work 70 hours a week. So
okay. Those are all the questions I have, Your Honor.
Okay, thank you, Mr. Johnson. Ms. Morton, do you have any questions for Mr. McNeil?
Just one. I'm just checking my email. It appears his Smart Start is locked out. When is the last time you took a PBT on your Smart Start device?
April 20th. I'm pretty sure when you violated me on that charge. April 25th. 25th or 26th. I'm sorry. Whenever you violated me on that, I quit doing them. I quit doing all the stuff you wanted me to do.
I have no further questions.
All right. Okay. So, Mr. Johnson, do you want to make any argument?
Your Honor, I think there certainly, by a preponderance of the evidence, have been some violations. I think my client does disagree with some of those violations, but he has admitted to the majority, and he's admitted that, frankly, it was just too much for him. So, Your Honor, we do agree that burden has likely been met. However, we would ask that the court take his circumstances into consideration.
Okay, well, I do find all of the violations have occurred, including the April 25th use or possession of alcohol based on a positive PBT. In fact, it was 4 different tests that all show a .046, 049, 042, 041. They're all within a range of tolerance that suggests they're accurate. And there's been no explanation offered as to why he would test positive. Defendant says he has no idea why he would be testing positive, but I have some ideas given that on 4/21, he went to the jail intoxicated, highly so, a .17 on a PPT. All right. Mr. McNeil, I don't need any help here. Okay.
Sorry.
And he had been released in the morning, apparently 5:21 a.m. That's plenty enough time for him to consume alcohol. And when I'm dealing with someone who has a serious alcohol use disorder, as evidenced by the Munson behavioral health screening, there's not much question in my mind what happened there. So defendant has, to his credit, admitted to all of the other violations, including getting intoxicated before he went to the jail in Leelanau. So I appreciate his honesty there, but he also admits that after the 25th, he just gave up and stopped testing altogether. And so anyhow, Mr. Johnson, is there anything more you'd like to say before I sentence Mr. McNeil on the probation violations?
Yes, Your Honor. Mr. McNeil admits that he simply cannot keep up with all of this. And, as Your Honor has pointed out, certainly alcohol use isn't going to help with that. That being said, he is working currently 70 plus hours a week for JP Landscaping. He does have a CPS case, which seems to be progressing. He indicates that he is getting some in-person at-home contact with his children again. That is supervised, but these are the first visits that aren't, I'm guessing, supervised by the state at one of their facilities. So he is moving forward there. I am confident, I'm sure, having been involved in these kind of cases, that drug and alcohol testing is a part of that case. So that will continue regardless of what happens here today on probation. He also has recently had his child support obligations raised. So working is obviously very important to him. Frankly, I think it's an idle hands argument that we have to make here, that we want him to keep working. We want him to stay busy because when he's doing that, he's not doing other poor things. Now, I've explained to Mr. McNeil, he's dug himself a hole here, and he's likely the only one who can dig himself out of this hole. Whether it's in the CPS case or this case, if this kind of behavior continues, he's not just going to lose certain liberties or freedoms. He could lose his kids, and that should weigh very heavily on Mr. McNeil. And I know that it does. And I know that that's his focus at this point in time. Your Honor, I do think that the recommendation is appropriate. However, if a limited sentence were possible so that he may be able to keep that job and keep up on his obligations, I know that would be much appreciated.
All right. Thank you, Mr. Johnson. So, Mr. McNeil, is there anything you'd like to say before I sentence you?
Yes, there is. Like Mr. Johnson just had said, Miss Mortensen works with Haley, the CPS lady, and back and forth, and they drug test me all the time, both of them. She shows up at my job site and drug tests me. CPS does. I have supervised visits on Wednesdays, and my dad supervises me on Sundays. I just got that granted to me last week. Everything is going good there, but it's just so much for me to do. I can't do it all, and that's all I have to say at this moment. My kids are my biggest focus. My kids are my biggest focus, and I throw the probation thing to the side because it just doesn't help me. I have a lot of things going on, and I'm in a really bad situation, and I'm trying to get through it.
What happened on the 20th with you turning yourself into the jail and being highly intoxicated.
I did all my 3 PBTs on that day, and I got intoxicated, and I turned myself in because that, he sentenced me to 6 days there. So I got drunk and turned myself in. I mean, there's nothing really on that. I mean, that's what happened, and that's what I did.
All right. Okay, thank you. Ms. Morton, anything you'd like to add?
Yes, Your Honor. When you sentenced him last time to 6 days, he wanted to try probation again after basically being gone for the whole year, blaming it on COVID and other issues. And my concern started right away when I heard he was intoxicated, turning himself into the jail. It obviously showed he didn't really want to try. And I suspect, and I have concerns that he's maybe not being truthful with his CPS caseworker, as I have had contact with Colleen Haley from CPS, and I assume she's assuming he's taking his PBTs through us. And I was assuming he was taking them until I just got the email. So I have concerns with that. But moving forward, those are my concerns moving forward with him and his kids and CPS issues.
All right, thank you. All right, well, this is sentencing on a number of probation violations with Mr. McNeil, and it's kind of sad that this started out with his family trying to convince him to go into rehab, and that's what led to the domestic violence conviction. Says the defendant was trying to start a fight with his brother, grabbed his shirt, pull him back, and had his fist raised to hit him. And according to his brother, the defendant did punch him on the right side of the head. The defendant has a prior history of, there was a domestic violence dismissed as part of a deferral, I believe, in 2016, and some alcohol offenses before that in 2002, 2004, and 2009. They're fairly minor in nature, but the intent of the probation here was to help the defendant become a more productive citizen and get past his alcohol issues. And unfortunately, the defendant has felt overwhelmed by those requirements. And now he's using the excuse of his child to try to avoid consequences for basically walking away from probation twice now, is what I would say. And frankly, I think his dishonesty to the assessor, his dishonesty in the pre-sentence report, his dishonesty today during his testimony that he didn't drink on the 25th. I don't know. I think they all militate in favor of a jail sentence here. So I am going to revoke probation. None of the goals of this probation having been met, and the defendant not even really making a serious attempt at it. I'm going to sentence the defendant to the maximum time that I'm allowed, which is 93 days with credit for time served. And the probation is revoked as unsuccessful. Fines and costs are preserved. That's it.
What is he turning himself in?
The defendant needs to turn himself in within by 6 p.m. tonight. All right, let's go on to Mr. Yarmouth's case. So is Mr. Hubble present?
Yes, Your Honor.
All right, so This is file 191607 SM, People versus Guillermo Yarmouth. And Mr. Hubble is here on the defendant's behalf. And it's my understanding that Mr. Yarmouth is going to admit responsibility to the violations. Is that correct?
Yes, Your Honor.
Okay. Mr. Yarmouth, is that correct? You want to admit to the violations?
Yes, Your Honor.
All right. And has Mr. Hubble answered all of your questions for you?
Yes, Your Honor.
You understand that you do have a right to a hearing to contest the allegations. Mr. Hubble would represent you in that, and you want to waive that right, correct?
Yes, Your Honor.
All right. No one's used any force or threats or pressure to get you to waive your right to a hearing today, have they?
No, Your Honor.
And no one's promised you what I would do as a result of the violations. Is that true?
Can you say that again? I couldn't hear you.
No one has promised you anything as far as what I would do about the violation. Is that correct?
You're correct, Your Honor. Your Honor.
Okay. All right, then. Says here that you were placed on probation for MIP 2nd on March 23rd of this year, and says as a condition of that probation, you were supposed to sign and return a release consent form, and you failed to do that when requested on April 8th, April 12th, and April 15th. Is that all true?
Yes, Your Honor.
Okay, and I do understand you finally did get the form to your probation officer on May 6th.
Yeah.
But, okay. The defendant says did not provide a discretionary drug screen on April 22nd or April 23rd as you were ordered. Is that correct?
Yes, Your Honor.
And drug screening was part of your probation conditions, correct?
Yes, Your Honor.
In addition, on April 28th, you did not sign or return your testing referral as you were instructed. Is that correct?
Yes, Your Honor.
All right. And again, the report notes that you did finally turn that in on May 6th. It also says that you're behind in payments, about $130 as of 4/28. Although, again, you did pay in full by May 3rd. Is that true?
Yes, Your Honor.
Okay.
Magistrate.
All right. So you did. Okay, good. All right. So as to all of those violations, how do you plead?
Guilty.
All right. I'll accept your plea. Find it's voluntary, accurate, and understanding. So, Mr. Hubble, what would you like to say on the defendant's behalf?
He provided me with information. He sent in emails to Miss Moore on April 8th and April 11th on 2 occasions, and he sent 2 out of the 3 forms back to her. He didn't send the release consent form. He thought he had. I think to some extent, he's not a techie and he's a little bit technically challenged. We, for the last 2 days, been trying to track down what he sent and get him to provide copies of those emails, and that was a bit of a heavy lift, but in reviewing all the information, it's true he did not return that particular form. I think he was trying to do that and failed to do so. With respect to the referral form, it's true he did not do that. he was sent emails that he should go in and test on the 22nd and the 23rd. He did not retrieve his emails, so he didn't see that. I don't think it was a willful effort to evade detection or anything. He just started a new job at Four Winds in Cadillac. He's working 45 plus hours a week. So that's a good thing. He supports himself and his two children. He is successfully completing all the terms and conditions of a probation in Wexford County and has done so for the last 5 months. So I commend him for those things. I asked the court to, follow the recommendations. I don't think his failures here merit jail time. I do think he's trying to comply. He is now fully paid on his fines and costs, and he's, I think, making every effort to comply with all the terms and conditions of probation. Because of his work schedule, if the court would consider just giving him an additional extra day of community service work instead of 2, that would be appreciated, because he's working Monday through Friday, gets there at 5 o'clock in the morning and works until at least 2:30 in the afternoon, and then some Saturdays. So that's why it's more than a 40-hour work week. But again, he's here to take responsibility and understands that he didn't do everything he was supposed to do when he was supposed to do it. And he understands that that is not what's expected of him by the court.
Okay. So, Mr. Guillermo, is there anything else you'd like to say before I sentence you?
No, he pretty much said it all. He is right. I seen what I messed up on by sending them all in. I'm not really on my email often, but I tried to check it when I can. And then when I was talking to Paul Hubble and the release form, I thought I sent it to her, but now that he was talking me through it, he showed me what it looked like, and I was honest and said, "Yep, that's the one." I thought it was like attachment on it, because I signed 2 other ones, but not that one. So that's what got me there. And then the test, I did not mean to miss, because I was working with my dad at the time doing concrete and barely on my email. So I'm trying to do everything right. And then I don't know if you want to know, in Wexford, I do have a counselor that comes here once a week, and I am in a every weekend I go to an alcohol class, like on Zoom. So, but other than that,
okay.
I didn't mean to violate any of them, but that's about it.
What are you on probation for in Wexford County?
A domestic.
I think it may be under referral, Your Honor. I'm not positive I recall, but I think that's what he's working towards.
Okay, so that's probably why it's non-public and we weren't aware of it. So,
yeah.
Okay, all right. Well, this is sentencing on a number of probation violations. Basically, the defendant not taking care of business here, and the explanation is that he didn't quite understand, what he was supposed to do or when, but you're, I don't know what, 21, 22 years old now. 21. And it's 21. Okay. You're old enough that you should be on top of this, and you should also understand this is one of those obligations for which you can go to jail, and I'm sure you don't want that to happen. So and Miss Moore shouldn't have to chase you down to try to get this paperwork. So I think it's reasonable what she's suggested here, the 2 days of community service work, but continue probation. The main goal here is to make sure that you stay on the right path. And I think all of the probation requirements are helpful with that. I will meet you halfway here. It sounds like you do have a busy work schedule, and you've got a lot else that you're dealing with. So I'll meet you halfway, and we'll make it 12 hours of community service work rather than the 16 that's being recommended. I give you credit for finally getting these sheets in at least, and sounds like you're sincere about trying to complete this probation successfully, and so that's all good. So so it'll be the 12 hours. You do need to contact Ms. Moore about how you're going to get that done, and we're all set for today. Yeah, go ahead.
I got a question for you.
Go ahead.
More, I got a mail in the paper. Do I still contact her? It says I got a different probation officer. So should I go to that one then?
Oh, that's a possibility. We've been doing a lot of shifting of cases lately.
He should just call the clerk.
So
Probation clerk.
what I would do is call the main number and find out for sure who you're supposed to be talking to. And have you got a pen handy?
I can get that information to Your Honor.
Okay, Mr. Hubble will get that to you. It's 922-6899.
Thank you very much, Your Honor.
All right, and just remember, Mr. Yarmouth, you know, you do have to make sure everything's being taken care of, and that's your responsibility, no one else's. And I'd rather see you be successful here, and the probation officers want to help you and see you be successful, but you've got to put the effort in also. Okay. All right. Well, thank you, and we're all set for today.
Thank you.
Thank you, Your Honor.
Do you see a Nicole Monkhouse?
I did have Monkhouse up here.
Was sent
Yeah,
over
there
by the
she is.
magistrate.
Okay, Miss Monkhouse, are you still there?
Yes. Yep, I'm here.
All right. Are you able to turn your video on?
It should be on. Let's see, I'm looking at, and I see that.
She's here on violations for probation, positive for amphetamines, buprenorphine, and THC on 5-3. And then alcohol on 5-8 at a 0.050, amphetamines, buprenorphine, and THC. And you should have that in your check-in.
Okay, so Ms. Monkhouse, did you hear Ms. Odom just indicated why you're here? And
Yes.
apparently you want to admit to the violations of your bond. Is
Yes.
it bond?
Probation.
Probation, okay. And have me sentence you on that, is that correct?
Yes.
All right, you understand you have a right to a hearing and to an attorney, including one appointed at public expense if you're unable to afford one. And you want to waive those rights?
Yes.
Okay. So, no one's used any force or threats or coercion to get you to waive those rights, have they?
No, no.
Okay, and no one's promised you what I would do in response to the violations, have they?
No, sir.
Okay. So, is it true that you were placed on probation for attempted assault with a dangerous weapon and attempted resist and obstruct a police officer back on April 29th? And as a condition of that probation, you were to abstain from using drugs or alcohol.
Yes, sir.
Okay, and is it also true that on May 3rd, you tested positive on a drug screen for amphetamines, buprenorphine, and THC, and you don't
Yes.
have prescriptions for any of those. Okay, and is it also true you tested positive for alcohol on May 8th? It was a 0.05, as well as amphetamines, buprenorphine, and THC.
Yes.
All right, then to those violations, oh, and it also says you didn't show up for your urine screen on May 26th. Is that true?
Yes.
Okay, and then to those 3 violations, how do you plead?
Guilty.
All right, I'll accept your plea. Find their voluntary, accurate, and understanding. So the recommendation here is for 5 additional days in jail. Go to once a day preliminary breath tests and continue probation. What do you think about that?
It really, it's very, I'm intimidated by it. It is a lot to do, and it's a lot to do. I'm trying my best that I could do. I kind of, when I got released from jail, I really thought I'd have a different place to live, and I'm kind of been starting over from ground zero as far as a home even. That's kind of where I'm at right now.
What's your living situation then?
I've been camping outside in a tent, actually.
Okay, at least the weather's nice, right?
Yeah, yes, it is this day today.
And so using a scram device really isn't a possibility for you then, because you need a power source for that.
Yeah, I should be able to move in with my friend soon. I'm just kind of waiting because I can't live alone. So I'm trying to. I have a woman working with me from Northern Lakes Community Mental Health, and she's going to help me with housing too.
Okay, good. How come you keep using amphetamines and Suboxone?
I think it's because I used to be on Adderall. I used to take that kind of medicine, and I do have ADHD. And at this point, I got weak. I got weak in the moment, and there's nothing I can say to excuse it from happening.
All right. Are you currently using, or where are you at?
No, I just got back on all my medications that I was supposed to be on. That's taken forever too, since I've been out. I was off my medicine there for a good while when I was released and did not know what to do there. But I found out how, and that's making me a lot stable, more stable.
So if I were to have you tested tonight, between 6 and 8:30, would there be any substances in your system?
Buprenorphine.
All right, and you don't have a prescription for that. You used to, I think, is what you said before, right?
Yes.
All right, well, this is what I'm going to do. I'm going to sentence you to not the 5 days, but 3 days in jail. And the purpose of that is to, you're going to go through some withdrawals there. And that's unfortunate. Jail's not the nicest place to go through detox, but that's the purpose of the jail time. And then after that, I'm not going to impose the daily preliminary breath tests but we're going to continue with the testing as ordered. And the reason for that is you just don't have a good way to test otherwise. But there's got to be some accountability. If you're going to improve your situation, you got to do something about the drugs and alcohol here. Okay. So otherwise, we'll continue all conditions of probation. And you need to turn yourself into the jail. Where are you? You're in Grand Traverse County, right?
Yes.
Okay. I'm not going to make you, I don't know. Do you have transportation to get to Leelanau? It's a jail. It's actually a nicer jail to stay at.
I doubt it, and that really sucks because I've heard that too.
Yeah, I mean, there's a bus route up there, but I don't know what their schedule is or anything, or but you'd have to get to the Beta bus stop to do that, and you need a bus pass. I don't know. Do you have bus passes?
I do, but I don't know if I could even make it up there. Is there any way I could go to the one here in Traverse?
All right, that's what I'm going to order, and I want you to put it on the dispo, Miss Odom, that she's homeless and she doesn't have a way to get up to Leelanau County, so she's going to turn herself into our jail. So yeah, you're going to go to the Grand Traverse County Jail. I'd like you to turn yourself in by 6 p.m. You can turn yourself in sooner, but no later than 6 p.m. And again, it's 3 days. So this is Thursday. You'll be out Saturday morning sometime. And hopefully we'll get you cleaned out and we'll start again. And hopefully things will go better, okay? All right, we're all set for today. Feel free to sign off, and thank you.
Thank you. Okay.
Yeah. All right, we're in recess then for the morning.